I am Prameela A, Assistant Professor in Law, Srinarayana Guru College of Legal Studies, Kollam. Today I am dealing with the general principles of contract, that is definition, elements of contract, classification of contract. Definition. Contract is an agreement which is enforceable before the court of law. So, agreement, it is classified as social agreement and legal agreement. Social agreement which cannot be enforced before the court of law. Then, I will give the example to social agreement. For example, A invites B to a dinner and B accepts the invitation. It is only a social agreement and it cannot be enforced before the court of law. So, it is not a contract. Legal agreement means it can be enforced before the court of law. A agrees to sell his house to B for rupees 1 lakh. This is a contract. So, contract equals agreement plus enforceability before the court of law. So, I can explain that all agreements are not contracts, but all contracts are agreement. That is, A agrees to buy B's car for rupees 1 lakh. This is an agreement and also a contract. A invites B to a dinner and B agrees. This is an agreement but not a contract. There are certain essential elements for the contract. Agreement, consensus at item, capacity of parties, free consent, lawful consideration, lawful object, not declared to be void. Then, I will give an explanation of each of the elements of contract. First, agreement. There must be an agreement between the parties of a contract. An agreement involves a valid offer by one party and a valid acceptance by other party. Therefore, agreement equals offer plus acceptance. There should be offer and acceptance in a valid agreement. Example, A sends a proposal to B to purchase a house for rupees 5 lakhs and B accepts that proposal. This results to a valid agreement. Second one, consensus ad idem. Consensus ad idem means, the meaning is presence of mind. The parties to a contract must agree upon the subject matter of the contract in the same manner and in the same sense. In other words, there must be identity of mind among the parties in the contract. This can be explained with a simple example. A has 2 houses, one at Trivandrum and another at Cochin. A wants to sell his house at Trivandrum and he is offering this to B and B accepts the offer, but B thinks that A is selling the house at Cochin. Here there is no identity of mind among the parties. Such kind of agreements cannot be considered and it cannot be considered as a contract. Third one, capacity of parties. Only a person who attains the age of majority, he can enter into contract. That means a minor's contract cannot be considered. Clearly saying that a minor's contract is void ab initio. That is void from the beginning itself. Only a person who has attained the age of majority can enter into contract and only that contract can be considered to be valid contract. Next is free consent. For the formation of a contract, one person must give his consent to the other person. The consent must be obtained free. That means it should not be affected by coercion undue influence, fraud, misrepresentation, or mistake. For example, A threatens B to transfer the properties in the name of B to A, and B is transferring the properties. But here the properties are transferred by B to A due to the threatening or coercion of A. There is no consent from the part of B. It cannot be considered as a contract. Next is consideration. Consideration means something in return, which is an essential element in a contract. In a lawful contract, there should be a lawful consideration. In every contract, each agreement must be supported by consideration. When one party agrees to give something, he must be benefited by the other party. This concept of this benefit is called consideration. For example, A offers to sell his house to B for rupees 10 lakhs. B accepts the offer. Here the consideration for the sale of the house is rupees 10 lakhs. And the consideration for B's payment of 10 lakhs is the house. Next is lawful object. For a valid contract, the object of the contract must be lawful. That is, only a lawful contract, lawful object must be there. That is, for what purpose this contract is made, that must be lawful. Then next is not declared to be void. The agreement might not have been expressly declared void by any law in force in the country. In such cases, the agreements cannot be enforced. For example, A agrees to supply some liquor to B. Subsequently, Prohibition Act comes into force. All the agreements to supply the liquor becomes void. Therefore, B cannot enforce the agreement which is made before the act came into force. The agreement has already become void from the date of the prohibition order came into effect. So, these are the essential elements of the contract, and all these essential must be there in order to create a valid contract. The next is classification of contract. The contract can be classified according to their legal effect, performance, and formation. Number 1, legal effects. It is classified as valid, void, voidable, unenforceable, and illegal contracts. According to performance, unilateral, bilateral, executed, and executory contract. And according to the formation, express, implied, and quasi-contract. First, valid contract. A contract which satisfies all the essential elements in a contract is a valid contract. All the essential element means I already explained it before, and the essential elements of contract. So a contract which satisfies all those essential elements, it is valid contract. Next is void contract. A contract which cannot be enforced before the court of law. It is not enforceable by law, and the agreement is without any legal effect. Next is voidable contract, and this is an important contract. That is, this contract, it is, even though it is valid at the time of formation, at the option of the parties in the contract, this contract can become void. That is, if A threatens B to transfer all B's properties in the name of A. Here A is threatening B to transfer all the properties. So B is transferring the properties in the name of A according to the coercion made by A. When this can be proved by B before the court of law subsequently, then this contract becomes void. Next is unenforceable contract. which cannot be enforced before the court of law due to technical defects. When these technical defects are rectified, it can be enforced before the court of law. Next is illegal contract. This contract is against public policy. It is a void contract. It cannot be enforced before the court of law. It is also an offense. Next is unilateral contract. Unilateral contract means a contract by which only one of the parties in the contract fulfills the obligation at the time of formation of the contract. Next is bilateral contract. In the case of bilateral contract, the obligation of both the parties is pending at the time of formation of the contract. Next one is the executed contract. If both the parties of a contract have performed their obligation at the time of formation of the contract, it is executed contract. Executory contract. An executory contract is in which both the parties in the contract have not performed their obligation wholly, or which there remains something to be done in both the sides. Next is express contract. Express contract, if the terms of a contract are expressly agreed, that is, which is expressly agreed at the time of formation of the contract, then the contract is express contract. That is, the terms of the contract must be orally or in writing agreements. Implied contract, or otherwise it is called tacit contract, and that is a contract which is made from the act or conduct of the parties. That means here, when a person is entering into a hotel to drink a cup of coffee, and when that coffee had taken by the person, it is his obligation to pay the amount of that coffee to the restaurant, and this is an implied contract. Next is a quasi-contract. Quasi-contract, the quasi-contract is not a contract. It can be considered only as a partial contract. So the quasi-contracts are not contract in the strict sense, which means it is not satisfying all the essential elements in the contract. But these quasi-contracts are the relations or obligations resembling those created by contract. So, law imposes an obligation to perform the duty. And this quasi-contract, they are based on the ground of equity. For example, A tradesman, he leaves his goods at B's house by mistake. Suppose B treats the goods as his own, then B is bound to pay a reasonable price of the goods. That is quasi-contract. These are the general principles of contract. Thank you.